WCLN 1170 Radio and Star Vision Cable Channel 16 are pleased to present We Should Know, hosted by J.W. Simmons, an upbeat, informative look at people, places, and issues facing our community. This education-based analysis of issues will remain positive and informative as we consider closely what we should know.
Ladies and gentlemen, welcome back. The name of the show is We Should Know. We do thank you for watching us on Star Vision TV, Channel 16. If you're listening to us, it's WCLN Radio. If you're driving down the road, hopefully if you hear something or something kind of interests you, if you're listening to us as you're driving, you'll have an opportunity to see this show on Channel 16 Star Vision on Tuesdays, Wednesdays, and Thursdays at 7 p.m. There's a summation reprint in the Sampson Weekly newspaper. I want to quickly give a shout out to Cliff Ireland with a Small Business Center. Sampson Community College, one of our sponsors for this show, for helping us kind of bring this show together and bringing our guest to us this morning. Great person. I'm looking for a lot of very interesting conversation out of the show today, and want to ask you up front if you wouldn't mind giving a neighbor, a friend, a call, tell them they might want to tune in. If you're in a business, own a business, or part of a business, you definitely need to be listening to the show today and call somebody and ask them to tune in. We're talking today with Paul Holscher. Paul is an associate in the Raleigh-Durham office of Jackson Lewis, and is also a North Carolina native. Paul, I want to thank you for being here. You've got an unbelievable broad amount of experience in the Affordable Care Act and other related issues as it relates to employability and what folks may need to know about that. I was reading that here in North Carolina, the Rising Star in 2011, 12, and 2013 editions of North Carolina Super Lawyer magazine you've been mentioned. So a lot of these issues we're going to bring out, and I want to first kind of let you talk about you a bit, because I know you've done some very interesting things, not just as a lawyer, but just as a person. I noticed if you walked the Appalachian Trail, and you've also run a half marathon down at Wrightsville Beach. I share that passion with you with running. I'm not in the category of a marathon runner, and I've noticed the older I get, the less that is. So tell us about Paul Holscher and a little bit so we can kind of get a feel for who you are.
Well, first, thank you for having me. I certainly appreciate this opportunity. I'm a North Carolina native. I'm from Washington, North Carolina. Of course, us natives from Washington, we like to refer to it as the original Washington. Those not from Washington call it Little Washington, but it's a beautiful small town 20 minutes east of Greenville. I grew up there, went to high school there, went to college at the University of North Carolina at Chapel Hill. After college, I worked for a bit on Capitol Hill with Walter B. Jones. Congressman is actually from my district in North Carolina. And then subsequent to that, I went to law school. And just prior to law school, as you mentioned, I spent about 3 months on the Appalachian Trail, which we don't have enough time to talk about all of that, but it was a really great experience. I started actually in Springer Mountain, Georgia, and walked over 1,200 miles and finished up in New Jersey. So I had a friend I started with and really enjoyed that. And it was really one of the formative events of my life, which I look back on with great fondness. And then I went to law school at Campbell Law School, graduated in 2005, and since then I've worked almost exclusively within in the employment law, workplace law area, advising employers about their obligations under federal and North Carolina law, trying to provide them legal advice, and also, if I have to, I've defended employers in numerous lawsuits in federal and state court in North Carolina.
Well, Paul, this is an interesting time that we're in now, especially in government and the impact of society and what the cultural understanding is of a lot of the issues and a lot of the things that you've done a number of publications on. Folks need to understand, but particularly today, as we look at the Affordable Care Act, which has often been referred to as Obamacare, these other issues, give us an overview, so kind of bring us up to speed and remind folks what we're talking about here and what this Affordable Care Act is.
You make a great point. There is various views upon the Affordable Care Act. Some people refer to it as Obamacare. There's some misinformation, disinformation about what exactly the law is. It was passed, interestingly, in March, on March 23rd, 2010. It was signed into law. And then it narrowly survived a U.S. Supreme Court challenge, and that's quite interesting because one of the major provisions of the Affordable Care Act is the individual mandate, which we'll speak to a little bit later in detail. But essentially, the individual mandate requires U.S. citizens to purchase health care insurance or pay a penalty or a tax, depending upon how you look at the situation. That issue, whether that was a penalty or a tax, was the main issue that the U.S. Supreme Court undertook. And it was really a surprising decision to many, because in a 5-4 vote, the Chief Justice, Justice John Roberts, who is a Bush nominee, some viewed as being a very conservative justice, actually voted with the more liberal majority of the court and upheld the individual mandate as constitutional. That was really a surprise. In fact, I heard some recent commentary from Jeffrey Tobin, who's a renowned constitutional scholar, published many books, who said that Justice Roberts actually had written an opinion declaring that the individual mandate was unconstitutional, and then changed his mind and reversed course and sided with the majority in holding that it was constitutional. The major issue regarding the individual mandate was whether or not the Congress had the power to impose a penalty/tax upon individuals to require them essentially to purchase insurance or pay that penalty. When the law was being discussed and debated, the Obama administration frequently referred to it as a penalty and not a tax. But interestingly enough, the U.S. Supreme Court decision, and the initial part of the decision, they say that it was not a tax, but in the later part of the decision they uphold it because it's a power within their tax and spending power of Congress to pass. So a really interesting evolution of the law. As I said, it survived that Supreme Court challenge, and so now it's the law of the land today. Where we are with it as we sit here today is there's 3 major provisions that begin to take place on January 1st, 2014. And those are the individual mandate, which I spoke about, which requires all U.S. citizens to purchase health insurance or pay a penalty tax. And there's also 2 provisions related, as referred to as the employer shared responsibility portion of the Act. And essentially what that says is larger employers that have 50 or more employees, are required to provide employer-sponsored health care coverage or pay a tax to the government.
So as we look at this program, this bill as it unfolds, started in 2010, it went through all of these kinds of, we'll call them gyrations, I guess, the Supreme Court. It's really a polarizing issue when it comes to the political environment. There's a huge differing of opinion based on whether this is, even now folks will say, still not constitutional. They still think that there's, and as you pointed out, the Supreme Court, there was this surprise as the Supreme Court voted in favor of this bill. But here's, I think, the bothering or troublesome question. As we look at this, the negative impacts as we go from a bill that started out with some 2,000 pages, and now it's up to 19,000 or so pages, the last estimates. How does bureaucracy typically deal with these kinds of things? And do we look at a huge financial cost as we move forward with this?
Well, the financial cost, depending upon who you ask, is certainly being debated. The Affordable Care Act, as written, was 2,000 pages, and since its enactment, there have been 19,000 pages of regulations, government regulations, to help implement the Act. It's one of the more major pieces of legislation that's ever been passed by our government. It's a polarizing issue because, as in many issues in Congress today, they're either declared a red or a blue issue and then voted accordingly. No Republican congressman voted for the Affordable Care Act. In fact, the House of Representatives has voted more than 30 times to repeal the Act or express its displeasure at the Act. So it is a polarizing issue. It's a polarizing law. But the main purpose of the law, one of the stated purposes is to try and address the increasing costs of health care in the United States. And one of the premises of the law is that large employers that have 50 or more employees, are going to be required to provide minimum essential coverage to their employees or pay a penalty. And in addition to that, that minimum essential coverage that they provide has to be affordable, or they could potentially pay a different penalty. That's called the play and pay penalty. But it is a very polarizing law. It's, as I said, no Republicans voted for it. It is the law of the land today, so attorneys at Jackson Lewis, including myself, are advising employers to start planning accordingly, and they should start planning now, because the penalty provisions of the Act start taking place on January 1st, 2014.
Well, Paul, as we sit here and talk about this, oftentimes, and I think you've noticed this too with your background, many times things start out with a reasonable good intention in the governing bodies, but time they end up on the ground working, they seem just not to come together as intended, especially in bureaucracy. Is that what you see happening with this law, with the volume of paperwork, with the number of bureaucratic levels and agendas, and with the fact that it is now, from what I can understand, and clear us up on this, the levying part of that is with the IRS?
Correct. Essentially, it is a tax. The penalty will be a tax. The individual mandate will be a tax on individuals, and then the potential employer penalty will be a tax on employers. You know, it's funny. It's a law that I think many people have differing views about. I do think the intent of the law is to try and address the rising costs of health care to individuals throughout the United States. And no one can deny the fact that since 2002, there's a survey from the Henry Kaiser Foundation. It's a nonprofit organization to try and provide non-biased information about the Affordable Care Act. And one of the surveys that they have done indicated that from 2002 to 2012, the costs for employer-sponsored coverage had increased 97%. And the cost for an employer, in other words, the employee's portion of that, what the employee pays to obtain coverage through their employer, increased 102% in that 10-year time. So we've seen a dramatic cost of health care for individuals in the United States. And one of the purposes of the Affordable Care Act is to try and drive down those costs by essentially requiring all individuals in the United States, all U.S. citizens, to purchase health care coverage, and also to try and provide relatively inexpensive coverage to employees via the employer-sponsored plans.
We're going to continue this discussion. We'll be back in a moment with Paul Holscher talking about the Affordable Care Act. Ladies and gentlemen, welcome back. The name of the show is We Should Know. I want to take a quick moment to give a shout out to some folks. Again, Cliff Ireland for helping bring together and have our guest today. We're talking with Paul Holscher. Well, the other thing I want to kind of mention is all of those folks that commented on our last two shows. Representative Dr. Larry Bell was here talking about what's going on in the legislature in Raleigh. Huge number of contacts, communications about that. We appreciate that. Also, Kim Reed, last show, we talked about Medicare, Medicaid, which is a huge discussion topic within itself. $1 trillion function here with the federal government. We talked about that, tried to decipher some of the more poignant subjects as it relates to Medicare, Medicaid, and we appreciate your comments on that. Also, I want to give a very quick shout out to Boogie Shoes Radio that mentions our show frequently on Saturday afternoon as folks kick back with Robert Stroud, Wayne Weeks with the gospel show that he does. Also, Don Smith on the Country Store, Tommy the Fly, and the folks on the morning show, Grandpa and the L Man and Nolan Z and all those folks. We appreciate your comments. So we're back with Paul Holscher. Paul, you are considered, I guess, if there is such a word, I don't know, seems like we don't use it much because people don't particularly like it, an expert in the field of working with employers and businesses, making sure everything is in line as it relates to government regulation. As on break, I mentioned, and we were just kind of chatting about that we live in a capitalistic society. When we look at the Affordable Care Act, and we see a lot of the things regulations that is built into that. As you mentioned a while ago, the design was to have everyone covered under some kind of medical care plan in the United States. If that goal is the case, as it unfolds from what you know and from where you sit as an attorney, and you've got a pretty broad field here, especially with some of the documents that you've done research on, are we really going in that direction, or is the cost of this program going to be so unsurmountable that we may never find the end to it?
Well, that's a great question. I think it is safe to say that employer-sponsored coverages for employees will probably increase going forward in 2014, and also the out-of-pocket expenses for employees may increase as well. I think it's going to take some time to figure out whether or not the Affordable Care Act accomplished this mission, which it's really twofold. I think one of them is to try and decrease the cost of health care coverage to U.S. citizens, but it's also one of the missions is to increase the amount of coverage. In other words, have more citizens obtain coverage. And it's interesting that you mentioned you had a recent discussion regarding Medicare and Medicaid, because one of the parts of the Affordable Care Act which we didn't talk about, which was actually struck down by the court, was its Medicaid expansion. And part of that provision in the Affordable Care Act, the Congress was saying, and the federal government was saying to the states, increase the amount of people that you provide Medicaid coverage for, or if you do not do that, we're going to take away all of your Medicaid funding. And the Supreme Court struck down that provision of the law and said that Congress was being coercive to the states. I heard a reference to the fact that that was almost a gun to the head of the states, that either they would have to increase their Medicaid coverage, or else they would lose all of their Medicaid funding from the federal government. It's interesting that that provision was struck down, so it was not mandatory, and allowing states to either opt in or opt out. Governor Pat McCrory decided to opt out of that. That Medicaid provision essentially said cover a larger group within your Medicaid coverage, and we will pay, the federal government said we will pay 100% of that for the first few years, and then starting, I believe, in 2017, it would pay 90%. And Governor McCrory said he wasn't confident that the federal government was going to hold its end of the bargain up, and therefore opted out of the Medicaid expansion portion of the Affordable Care Act.
Paul, when we look at North Carolina's not the only state that has done that. A number of states has opted out. What is really that saying, and what is the impact to the state as you see governors saying, well, look, we don't want to get into that, because it's been a big debate, I think, in Raleigh, depending on who you talk to, whether that was a good idea or a bad idea.
There was some unfortunate timing with that from a Democratic side, in the sense of right around that same time there was a study audit done of North Carolina's Medicaid system, which showed that there was about $14 million in administrative costs that weren't necessary. So essentially, at the same time this issue was being debated, there was a study that showed that there was inefficiencies within the Medicaid system in North Carolina. I do think one could argue that opting out is obviously going to mean that poor individuals in North Carolina may not be able to obtain coverage through Medicaid, which they otherwise would have been able to obtain if North Carolina had opted in. So that obviously is a polarizing issue within our state.
And we talked about this question, and you alluded to it a while ago. We talked about the 50 employees or more. Is it also true that even a person that's out there working, maybe there, and of course Eastern North Carolina, agriculture is a big business in Eastern North Carolina. We've got other industry obviously, but agriculture is the huge industry. And you have agricultural folks, farmers and different people that have less numbers. Will it not impact them also, except it's kind of not in a direct way, an indirect way, as the insurance companies look at costs and they level the playing field as it relates to costs?
You could argue that the Affordable Care Act may end up increasing costs for all employers that try and provide employer-sponsored health care plans. But I will say this, and this is another one of the misconceptions we talked about earlier about the Affordable Care Act, is that in its enactment, the Henry Kaiser Foundation, which I referenced before, they have an online survey, and many people believe that the Affordable Care Act is saying to all employers that you have to provide an employer-sponsored health care plan to your employees. That's not the case. As we alluded to, it's only employers that have 50 or more employees. Well, the next great question is, well, what do you call an employee? And the Affordable Care Act says if you work at least 30 hours a week, you're a full-time employee. There's also a part of the law, I recently had a presentation on this same topic, and one of the attendees said, well, I'll just change my full-time employees to part-time employees, and therefore I won't hit the 50 employee equivalent. Well, the drafters of the Affordable Care Act thought about that, and so there's an equivalency rule such that if you have 2 part-time employees that are working 30 hours a week, that counts as 1 full-time employee. So really when we talk about 50 employees, we're talking about 50 full-time or full-time equivalents. In other words, you can't have 40 full-time employees and then have 30 part-time employees and claim not to be subject to the Affordable Care Act. There's equivalency rules for part-time employees.
So this is really when we look at it, and I know we're saying things that's probably already been said in news media in the past few years, but this is a huge impact when it comes to businesses, because they've got to sit down and look at their bottom line and say, you know, is this something that we can really deal with? And there's got to be an adjustment. So how does business, as you're talking to business people, how are they adjusting to this? Because oftentimes, I mean, over 50 employees, you may have 100, you may have 75. How does business handle that? What are you hearing from business people?
Well, it really depends upon the specific situation and the business. It's really a subjective decision from the business. There are many different factors which a business may take into consideration to decide, well, if they don't currently provide health care coverage to the employees, whether or not they will or whether or not they'll decide to pay the penalty under the Affordable Care Act. One major consideration for employers is how important is health care coverage to my employees. As you said, we live in a state that has a growing business area. The RTP Triangle is a really competitive market for businesses, and so many employers may take the position that, well, to attract a top talent, we want to have an employer-sponsored health plan, and therefore if we don't, our competitors are going to get the best, most qualified employees because they're going to offer one. But other considerations obviously is the size of the employer, and considerations regarding, as I said, whether or not their employees are attracted to that employer because of an employer-sponsored health care plan. So there's many different factors that an employer is probably going to take into consideration. But that also brings up an interesting point in the fact that the penalty, if you do not provide health care coverage under the Affordable Care Act, generally speaking, is going to be less than the cost of coverage. In other words, it's really going to be a subjective opinion whether or not you provide health care coverage, because the penalty is going to be less than the cost to the employer if they did.
So basically, folks who say, well, I'm just not going to do it and pay the penalty, and so they would come out better as far as a business decision financially to just pay the penalty and move forward. So again, back to the penalty part, the enforcement side of that, how is that going to be enforced, and who leverages the enforcement? Does that come through the IRS? Are people going to look at that? Are they going to wait for whistleblowers to call in and say, look, I work at a company, there's 60 people here and they're not paying for my insurance? How does that happen?
Well, essentially, it is going to be enforced as a tax. As I said, there's 2 separate penalties. The first penalty is if the employer does not offer minimum essential coverage, and the other penalty is even if they do offer minimum essential coverage to the majority, 95% of their employees, that coverage has to be affordable. But you're right, from a pure financial perspective, it will be cheaper for an employer to say, I'm not going to employer, of course being defined as one that has 50 or more employees, to say, I'm not going to offer my employees an employer-sponsored health care coverage, and therefore I'll be willing to pay the penalty. And in a sheer, by way of example, an employer that has 100 employees, if they decide not to offer coverage, that yearly penalty will be about $140,000. Again, that's quite a bit of rounding there. But that obviously is less than what it would cost for that employer to provide health care coverage to its employees.
A huge decision that employers are going to have to make. I want to go to break now, but when we come back, I want to talk about that affordable part a bit and defining affordable and what that is. But I want to go to break now, and as we do that, I want to just kind of a quick comment as we go to break, and we've got about 10 seconds, 15 seconds here. I want to remind folks we're talking about a very serious cost issue that affects you, everyone that's listening today. We got a person here by the name of Paul Holscher. It's an attorney that really understands and can explain questions and comments about this. So I encourage you to call a friend, neighbor, somebody that you know maybe is in business, to tune in and listen. Hopefully we'll answer some of your questions. We'll be back in a moment with We Should Know. Ladies and gentlemen, welcome back. We're talking to Paul Holscher. He's an attorney out of Raleigh, Durham with Jackson and Lewis, North Carolina native from the original Washington, as he says, here in North Carolina. Little Washington is referred to, is his home. A number of publications I found interesting that he has done, and there's really too many for me to go over all of them. One of them that was interesting to me as I looked at it, these are just topics. We're not particularly talking about these topics today, but he's done a lot of research and conducted a number of workshops and publications. One of those was conducting effective workplace investigations, a how-to guide. The other is North Carolina enacts comprehensive reform of employment insurance system. Another interesting topic, unemployment benefit claims, issues, strategies in North Carolina. Just a huge number of things that you've been involved in, Paul, that I think is attributes to your background and expertise in this area. And again, we thank you for taking time to come in and talk to us. We're talking today about affordable health care. The original idea of this program, as it was pushed through Congress, as it was passed and given a nod by the Supreme Court, although it was not unanimous, and there was some decision-making process there, was that everybody would have some sense of health care, that folks would not show up, I guess, at emergency rooms throughout the country, and hospitals have to pick that up, or that it would be picked up by Medicaid or some other program. Is that idea, from what we see happening now, is that really realistic in a society in which some estimates say 12 million plus citizens that we don't even know who they are here? Is it a realistic, and as we move forward, is that going to impact all these issues?
Well, obviously Tom's going to tell about how effective a program it's going to be. I think one can't argue that something had to be done regarding the increased costs in health care. And I do think, regardless of party affiliation, most Americans would agree with many provisions of the Affordable Care Act, such as one of the more popular provisions is you can't deny coverage to someone due to a pre-existing condition. Another provision of the Affordable Care Act allows dependents, that being sons or daughters, to stay on their parents' health insurance plan until the age of 26. So there are provisions within the law, I think, that most Americans would agree are good for Americans and will expand health care coverage. Now, whether or not 20 years from now we'll look back and be able to say this law was one that drove down the cost of health care or increased healthcare coverage, that's debatable, although I do think that it was a step that needed to be taken, and it has been a huge undertaking for the government to try and carry out. And as I said, beginning January 1st, 2014, the wheels are in motion now, but really the game really starts on January 1st, 2014, when the individual mandate starts and also the employer shared responsibility portions of the law begin to take effect. It will be enforced by the IRS, and the penalties, taxes, however you'd like to call them, will be enforced by the IRS and paid to the government.
Paul, we talked about, and the word, we've used it several times here, the word affordable, and that folks are required to have affordable health care. Let's get into that word and definition of that as it relates to the Affordable Care Act or Obamacare. What does affordability mean to the person that's the employee, and does it mean something different to the person that's doing the employing, i.e. the business or the company or corporation? That's the dynamic driving word, I think, which relates to money, is affordable.
That's a great question. As I said, we're talking about two different penalties, and it's easy to get them confused. The first penalty is essentially whether or not the employer decides to offer minimum essential coverage to their employees. As I said, they have to be an employer with 50 or more employees. They have to offer that coverage to 95% of their employees. And if one employee within their organization goes out and obtains subsidized exchange coverage, then that's the play or pay penalty. That penalty gets enforced. The second penalty deals with affordability. That's often referred to as the play and pay penalty. And that's if the employer offers minimum essential coverage but yet that coverage is not affordable. In the regulations issued by the government, they've defined several affordability safe harbors, if you will. That being where the employer can say this coverage is affordable because of X, and that X is if the coverage is not more than 9.5% of the employee's W-2 wages. If it costs less than 9.5%, it's deemed affordable under the Affordable Care Act, and therefore that employer would be in compliance with the play and pay penalty provision and not have to pay the penalty.
Which is a huge chunk of a paycheck. When you look at 9.5%, if it's right on 9.5%, and you add that to an already existing, the FICA and the other taxes that comes out of an employee's paycheck, that's a huge impact. So a person could be taking home actual cash that goes in hand that they can use, sometimes 50-60% of their dollar, correct?
Well, it does seem a rather high percentage of a paycheck, but I do think, as I said, one of the goals of the Affordable Care Act is to try and provide affordable health care coverage, and so requiring that employer to set a bar to which the coverage costs is perhaps a good way to judge whether or not the Affordable Care Act is making a difference.
And as we look at this, one of the pieces I want to talk about too, and I'd like to kind of maybe build this in now, I've talked with a number of physicians and doctors and in both private practice and in clinic practice and settings. There's some concern here how this particular Affordable Care Act is going to impact going forward the whole industry of medicine and healthcare on the professional side, i.e. specifically doctors and folks looking at careers. There's comments I have received from folks in the medical profession that going forward, folks that maybe in their 50s or 60s, had they known earlier in their career that this was where they would be looking at and what they'd be looking at as far as healthcare, they may not have chosen medicine as their career path. Is there some negative impact we're missing or not understanding that's going to impact income for doctors in the sense that doctors have always been kind of recognized as highly skilled positions, very obviously very academically achieved people, and they're paid, at least in my opinion, salaries that is justified because I certainly don't want to go to a specialist that's making $20,000 a year and say, how about operate on my leg or something. Say, speaking not for them, but just an observation. Is it going to impact them in such a way that we're not going to have the kind of people maybe stepping forward because of the cost?
I'd probably say no in the sense of I think there's going to be an even greater demand in a sense for these skilled positions. But that saddens me to hear that some may believe that. I think that's related to one of perhaps the criticisms of the Affordable Care Act in which it did not include a tort reform part of the Act. In other words, it did not address what some people view as a civil tort system that's a little out of control in regards to medical malpractice and the like. I am aware that medical malpractice rates have increased in recent years, but I would say the Affordable Care Act does have provisions regarding preventative care, which I think may address some of those issues. But again, I think time is going to tell whether or not it's going to affect salaries of those doctors and physicians that provide care.
Well, we always hear this comment too, and of course I've had a number of listeners to email me or stop me and say, well, speak to this on your show, and one of those is this idea of a comparison of social medicine and Affordable Care Act. That language is kind of used synonymously in discussions, that this is another form of socialized medicine in the United States compared to some European countries, compared to Canada and that kind of thing, which there has been some pushback and some observations that might not be the best system. Is it okay or not okay, or are we missing the definition when we use social and the Affordable Care Act?
Socialized medicine is definitely a loaded term, if you will, for many folks.
It is.
By definition, I don't believe the Affordable Care Act can be described as socialized medicine or a single-payer system. I do believe that it does attempt to expand the coverage of various Americans. In other words, allows more Americans access to coverage. But I think labeling it socialized medicine may be a bit of a misnomer.
The polarization between the political parties on this, and of course, you've done some work and you understand that, working with Congressman Walter Jones and those folks. Was there an alternative to this, or is this something that needed to come through at the time that it came through as a effort to do something about health care? When we look at the pullback from the Republican Party, was there something else there that may have been, from your observation, a better kind of approach than what we're now into?
I think that, and again, I don't want to play politics here or take a political
just
position.
An observation.
But I would say that one of the criticisms from the Democratic side is that there really was never a formal alternative to the Affordable Care Act proposed by the Republican side of the legislature. In other words, there were just criticisms of the Affordable Care Act, but an alternative means of lowering health care costs was never really proposed. But again, this is obviously a very polarizing law. Not a single Republican congressman voted for it, but it's the law of the land, and we're advising employers to obviously take it seriously. And starting January 1st, 2014, there'll be penalties both to employers and individuals related to the act.
And those penalties, if leveraged, will be brought from the IRS. And Internal Revenue Service, which a lot of folks now is using that kind of as a red flag because of some of the issues that IRS has recently faced. They're saying, wait a minute, these folks are going to enforce this law and they can't deal with other things. So that's going to be a key issue.
Essentially, employers will be audited, and then they'll have to be notified by the IRS whether or not a penalty is going to be assessed.
We'll be back in a moment with We Should Know. Stay tuned. Ladies and gentlemen, welcome back. I'm pleased to tell you we have Paul Holscher with us today. If you've not been listening to the show, if you have been, you know a little bit about his background. Paul is with Raleigh-Durham office of Jackson Lewis. He's an attorney, specializes working with businesses, industry, employers, in dealing with a massive amount of information, a lot of workplace issues, well published in areas that deal with a range of workplace issues. Paul has taken time today to come in and talk to us about the Affordable Care Act as it's going into full implementation January 2014. A huge number of issues. Again, Paul, thank you for coming in, and I just feel that there's so many things we talked about on break. I mentioned I think we could talk for a week and just still not cover everything, but recently, two Supreme Court decisions have come out that I think we need to mention, and I'll allow you to discuss those, that is affecting and going to affect workplace, a lot of people's lives. Let's talk about those, and these are very recent things.
Well, the timing here is really impeccable in the sense of there's been several decisions from the U.S. Supreme Court recently that directly impact businesses, employers in North Carolina. One of those decisions was a case involving a same-sex couple from New York. And that same-sex couple, one of the members of the couple passed away. They had been legally married in New York, which recognized same-sex marriage. But due to DOMA, with the Defense of Marriage Act, which essentially stated that states and the federal government don't have to recognize same-sex unions, the surviving spouse, Windsor, inherited a $363,000 estate from her deceased spouse. Well, under federal law, she was required to pay estate taxes on that estate, and she challenged that, saying that DOMA was illegal and it violated her equal protection rights, because if she had been a man, she would have been entitled to an exemption and not have to pay that estate tax. In another landmark decision, the U.S. Supreme Court struck down DOMA as unconstitutional, as violating the Equal Protection Clause. Now, how does that affect North Carolina employers specifically? Well, one way is the FMLA, which is the Family Medical Leave Act. That act requires employers with 50 more employees to provide unpaid leave in certain situations, one of which is to take care of a spouse who has a serious health condition. Well, now that DOMA has been overturned, overturned. There's some that believe that under the FMLA, if a same-sex spouse couple resides in North Carolina, a North Carolina employer, if they were legally married in another state that recognized same-sex unions, a North Carolina employer would have to provide FMLA leave to that employee to take care of their spouse.
So in that case, federal law would supersede state?
Federal law, the FMLA would be required to provide, the employer would be required to provide that leave of absence for that employee.
Going forward, when we think about this, what are the other things that's impacting as it relates to this particular Supreme Court decision?
Well, coupled with that decision on the same day, Prop 8, which was a California law which prohibited same-sex unions, was in effect overturned. The Supreme Court said that the challengers to that law didn't have standing, so in effect it affirmed a district court decision from California declaring that law unconstitutional. So what we're going to see is expanded rights for same-sex couples going forward, and as I said, the FMLA is a prime example of that.
So there's direct relationship here, although a lot of folks says, well, it's not going to impact North Carolina simply because North Carolina is going to have a kind of I guess, a vessel that surrounds it that says we're not going to deal with federal law as it relates to this, but these are issues that are going to be not necessarily problematic, but something that's going to be of issue when they come up if that happens in North Carolina, and we may not know that until it happens.
We may not know that until it happens, but essentially federal law does trump state law, and therefore, as an example of the FMLA, employers are going to have to provide that leave to a same-sex couple that's been married in another state that recognizes that union between the same-sex couple. So.
What about companies, organizations, as it relates to discriminatory issues, and somebody says, well, I'll solve the problem, and an employer says, well, I just won't hire anybody, that I know to be, same-sex married or whatever. I just won't hire anybody like that. Is that not as well a federal violation? Mm-hmm.
Well, that's a great question. Title VII, which is a federal law, which is part of the Civil Rights Act, prohibits discrimination on a numerous bases, including gender, age. It's enforced by the EEOC. I wouldn't advise any employer not to hire someone simply because of that applicant's sexual preference. I advise all employers that ask me questions in this area to really decide, make hiring decisions and decisions in the workplace solely based upon non-discriminatory factors such as performance and qualifications. So that's an issue that employers need to be aware of.
There's a lot of these issues that we talk about, and we're touching on a number of these today, and I'll go ahead and say to our listeners, we're not going into them as in depth as I would like, and I think you and I have talked about this. You can only touch on them, but the key important thing here is some of these things, if you're an employer or even if you're an employee, you might want to follow up on so you can understand what's happening here, because it may or may not impact you, and when it does, you need to at least understand this is a problematic issue, and to call on somebody like yourself or others that deal in this on a regular basis, that understand the statute and laws. Is the complexity of these laws, Paul, going to be such that it's almost going to be necessitate or have to have a person like you or others to come in and deal with these because of the complexity?
Well, that's another great question, and I think it leads to a characteristic of Jackson Lewis, the law firm I work with, which I really admire, and we advocate preventative, that the employers take preventative action. In other words, we're big on training. We're big on having HR managers and decision makers being current on North Carolina as well as federal law, because I do believe you can pay an ounce in prevention, and that'll take away maybe a pound later on in a lawsuit and that type of thing. So one of the benefits of our firm is that we do quite a bit of training of HR professionals and decision makers to make them aware of all the applicable federal and state laws, and advocate that they take measures to train their own employees so that they're aware and up to date on all the laws that may come up in making decisions in the workplace.
Huge number of questions for businesses, for industry. As we move forward and we look at documentation and some of these things, I know you've written some stuff on, how long do you keep records and electronic records versus hand records and those kinds of things. When we look at the Affordable Care Act, documenting employees' issues and concerns. A part of that is going to be up to the employer to document these things, so in case there is an issue, not necessarily for litigation, but just for explanation, they have these things on file.
That's a great point. I think many employers fall into the trap sometimes where they don't document their decisions in the workplace enough, and we haven't had time to touch on it, but one of the provisions of the Affordable Care Act is that it provides a whistleblower protection to employees such that an employee can't be terminated related to engaging in protected activity related to the Act, which could include obtaining subsidized exchange coverage, also making complaints about violations of the Affordable Care Act. So all employers should take various measures to not only have up-to-date employee handbooks and policies, but communicate those to employees, and also take great care to document employee discipline, the reasons for the discipline. All those types of issues need to be addressed by employers, especially in today's society where we have an employment law environment that's just changing literally on a daily basis.
Just a couple of, I just got a couple of more questions I want to kind of throw on the table. One of those is a crystal ball kind of question, I guess. We all recognize that there's something that's got to be dealt with as far as immigration and immigration law. Huge discussion on the federal level, discussion on the state level. Employers in North Carolina truly understand that and are with a program. What do you see, in a crystal ball question again, happening as it relates to immigration and the impact on the Affordable Care Act going forward?
Well, that's another good question, and the timeliness here is really impeccable. Just recently, the United States Senate has taken up some serious debate and is close to passing a comprehensive immigration reform bill. It'll be the first comprehensive immigration reform bill in quite some time. Now, that's just a bill, it's not a law, but it's one that has gained quite a bit of favor among Democrats and Republicans recently, and it really is going to, if passed, overhaul the U.S. Immigration system. There's various provisions in that bill, in that potential law. We don't have time to get to all of them, but nevertheless, it does. Part of the purpose of that law is to try and provide a means by which 11 million undocumented immigrants in the U.S. can have a pathway to citizenship. Mm-hmm. And also more from, you could say, the Republican side, there's measures in the bill to try and increase border security and to discourage illegal immigration into the U.S. So it's going to be really interesting to follow that law in the next few weeks, the bill to see in the next few weeks to see if it's passed.
Huge financial concerns, and basically we're talking large amounts of dollars, and again, the bipartisan, I think, approach to trying to do something regards to immigration could have major impact on the whole issue of affordable health care. I want to give you, we're kind of coming to a close, I want to give you a few seconds here to just kind of wrap up. And of course I want to, if you don't mind, give folks a telephone number, so they can call you in case they're listening. They want to, give you a call and say, hey, need you to come out and talk to us, or come out and take a look at what we're doing with our company or business.
Well, one issue we wanted to get to but ran out of time is North Carolina's reform of its unemployment benefits system. Mm-hmm. Those reforms was passed in February by Governor McCrory. Mm-hmm. Those reforms apply to claims filed on or after July 1st, 2013. There's a reduction in the amount of benefits, the duration of benefits. There's also elimination of the substantial fault defense, which is partial disqualification from unemployment benefits. So there's a lot going on in the legal workplace now for North Carolina employers to be wary of, including the recent changes to the unemployment benefits law. As you said, I work at Jackson Lewis. We're a national labor employment firm. We have a website, jacksonlewis.com, and I'd be happy to answer any questions that any folks may have.
Okay, and that phone number, 919-854-0044. Okay, folks, we've been talking with Paul Holscher. Paul, I want to thank you for being with us today. You've been watching We Should Know. Look forward to your comments, questions. We should know, edu@gmail.com. See you again next week on the radio.
Thank you for tuning in to this week's episode of We Should Know with host J.W. Simmons. If you have a question or comment regarding this or any episode, please send your email questions and or comments to jwsimmonsedu@gmail.com. And remember to tune in every Tuesday afternoon beginning at 2:30 for another informative episode of We Should Know.